Thank you, Faizin, for the introduction. Now let's go straight to the discussion. Our discussion today is on the directors and managers' criminal liability, the legislative and common law approaches in Tanzania. Now, to start with the rationale for the corporate criminal liability. What is the reason for holding companies and the directors criminally liable? One of the reasons for holding companies and the directors criminally liable is to make sure the directors and managers, being policy makers of the company, take reasonable steps to prevent the crimes within their workplaces. Managers and the directors are deemed to be the company. They are deemed to be the company because they are the ones making policies and they are the in charges of the daily affairs of the company. For that reason, they have power to make sure the crimes are not committed within their workplaces. So when crimes are committed within the workplaces, directors and managers are deemed to have taken part in committing those crimes, or they are deemed to have allowed the commission of those crimes for failure to prevent them. So by holding the directors and managers criminally liable, they are in a way forced to make sure they put in place policies and other ways of preventing the commission of crimes within the workplaces. The second reason is to ensure compliance. When managers and the directors are held criminally liable, it helps in enforcing compliance by legal entities, because the directors will be afraid of being prosecuted. And by being afraid of being prosecuted, they will have to make sure everything is done to comply with what the law requires the companies to do. Now, what are the approaches? What are the corporate criminal liability approaches taken by Tanzania? Tanzania takes two approaches to corporate criminal liability. One is their companies and the directors can be charged for penal offenses under penal statutes, like the Penal Code, the Economic and Organized Crime Control Act, the Prevention and the Combating of Corruption Act, the Drug Control and Enforcement Act, and even the Prevention of Terrorism Act. So the company can be charged with a pure penal offense. The companies and the directors can also be charged for offenses created under the regulatory laws, like the Electronic and Postal Communication Act and the Tax Administration Act. Many directors and companies are charged under the regulatory laws, and there are few directors and companies who have been charged under the penal statutes, like the Economic and Organized Crime Control Act or the Prevention and the Combating of Corruption Act. Now, when charges are preferred under the penal statutes, there is a condition that the prosecutor has to prove the actual participation of the director or a manager in committing the crime. And when we are talking about directors and managers, we mean executive directors and managers. We don't mean non-executive directors and managers who only take part in the board meetings. So one of the conditions for charging a director or a manager or prosecuting him and having him convicted is such a director or a manager should be what we call a corporate mind. A corporate mind in the sense that he or she is in charge of the daily affairs of the company. If the director is just a non-executive director, only sitting in the board meeting, he cannot be charged for a criminal offense committed by the company because he is not in control of the company, and in no way he could avoid the commission of a crime by the company. Now, why companies are charged under penal statutes? The companies are charged under penal statutes on the basis of Section 4 and Section 71, sub 1 of the Interpretation of Laws Act. Under those two provisions, the word person, when used in any written law, includes a corporate body, natural person as well as a corporate body, whether the corporate body is incorporated or unincorporated. So prosecutor can prosecute the company and the director for a penal code offense like forgery, uttering false document, and so many other offenses under the penal code based on the interpretation of the word person as provided in Section 4 and the Section 74(1) of the Interpretation of Laws Act, because the company is also deemed to be a person, and therefore any crime committed by a company, the company can be prosecuted for it. Now, the prosecutor may also charge the directors or managers under the company under the regulatory laws. Regulatory laws are such as the revenue laws, telecommunication laws, media laws, mining laws, oil and gas laws, environmental laws, transportation laws, energy laws, etc. When the company is charged under the regulatory laws, prosecutor is not required to prove the actual involvement of the director or a manager in committing the crime. Director or a manager will be prosecuted by virtue of his position. Director or a manager will be prosecuted because of the position he's holding, and not because of his actual involvement in committing the crime. How is this possible? What the prosecutor will be required to prove is a crime was committed at a workplace. It is not necessary to prove who was the actual offender or a perpetrator of the crime. Once it is committed, once it is proved that the offense was committed at a workplace, then the liability of that unknown individual within the company shall be imputed to the company. The company shall be deemed to have committed the offense just because someone within the company committed the crime. Then the liability of the company shall be imputed to the director. This is what we call the doctrine of imputation or attribution. You prove that the crime has been committed, then the liability of that unknown person within the company is imputed or transferred to the company. The company becomes guilty because its official committed the crime. Once the company becomes guilty, the guilt of the company is transferred to the director. So that director becomes guilty because the company is guilty, because someone within the company committed the offense. Once the guilt of the company is transferred to the director then is required to prove that he did not know that the crime was committed or was being committed within his company, or that he could not have reasonably known that the offense was being committed within his company, or that he knew that the crime was being committed within his company and he exercised all the due diligence to prevent the commission of the offense, but he failed. If a manager or a director is able to prove that, then he will be excused. He will be declared innocent. He will be acquitted. But if he fails to prove that, then he's deemed to be guilty. In other words, criminal liability of directors for regulatory offenses is assumed. Director is assumed to be guilty by virtue of the position he is holding. He is deemed to have failed to prevent the commission of an offense. In criminal law, if a person is in a position to prevent the commission of a crime, and he is aware that the crime is being committed, but he fails to prevent the commission of the crime, such person is deemed to have aided or abetted the commission of the offense committed. So directors are held criminally liable for regulatory offenses because by failure to prevent the commission of the crimes they are aware of, they are deemed to have aided or abetted the commission of the offenses. This principle of assuming the criminal liability of a director doesn't apply when a director or a manager is charged under the Penal Code or the Economic and Organized Crime Control Act, which do not have the specific provisions holding directors criminally liable. The imputation principle is only used when the company and the directors or the managers are charged under the regulatory laws, like the media service laws and other regulatory laws that we shall look into. Now, who is the directing mind? Who is deemed to be the directing mind? What is the test do we use? What test do we use to say this officer in the company is the director? Is it the name? Is it the title? The answer is no. In some companies, a directing mind or in charge of the corporate affairs may have the name of managing director, executive director, general manager, chief executive officer. Whatever name or whatever title is assigned to that officer, depending on the corporate structure, the test is whether a person is the directing mind, in the sense that is he in charge of the daily affairs or daily operations of the company? Is he in control? Is he in a position to prevent the commission of the offense? Those are the tests we use to determine who is the corporate mind who should be charged for failure to prevent the commission of the offense. Who should be charged as a director for the offense committed by the company? Well, let's look at the essential features of corporate criminal liability in Tanzania. Only the directing mind is held guilty for a corporate offense. For someone to be charged as a director, he must be in charge of the daily affairs or daily operations of the company. Then the law allows charging both the director and the company. Why both are charged? The reason is company is charged because someone within the corporation has committed a crime. So the liability or the guilt of an individual in the company is imputed to the company. So the company becomes an offender because guilt of someone within the company has been imputed to the company. And then the director, the guilt of the company is imputed to the director because the director is deemed to have failed to prevent the commission of the offense. And for that matter, the director is an aider. So director is charged along with the company as an aider or abettor, and the company is charged as the actual perpetrator of the crime. I will repeat this. Why company and director are charged together? The company is deemed to be the actual perpetrator of the offense, although the company cannot commit a crime. Company cannot form guilt intention to commit a crime. Company cannot do what we call a criminal conduct. But company commits crime through individuals within it. So when an individual commits a crime, then the criminal conduct of the individual, the guilt intent of the individual is deemed to be the guilt intent of the company, and the criminal conduct of the individual is deemed to be the criminal conduct of the company. So once that is proved, then the company is held criminally liable. And the criminal liability of the company is then transferred to the director. Why transferred to the director? Director is deemed to have aided the commission of the offense by the company or by an individual in the company by his failure to prevent the commission of such offense until he proves that he was unaware of the commission of the crime, or he was aware and he did all what he could have reasonably done to prevent the commission of the offense, but he failed. Now, let's look at the common questions that arise from corporate criminal liability. One of the frequently asked questions is, how many directing minds can be assumed guilt of one corporate offense? If an offense is committed by the company, how many managers or how many directors can be prosecuted? The answer depends on the corporate structure and the nature of the offense committed. If the nature of the offense committed and the corporate structure dictates that two or more managers or directors must have known or ought to have known that the crime was being committed, then two or three of such managers or directors can be jointly charged, because they are deemed to be corporate minds in the sense that they were in control of the company, they knew the crime that was being committed, and they failed to take reasonable steps to prevent the commission of the offense. So it is the answer to that question depends on the nature of the offense committed and the corporate structure. Another frequently asked question is, what is the standard of proof required for a director or a manager to be acquitted? As we have seen in regulatory offenses, when a director and the company are charged with the regulatory offenses, the law shifts the burden to the director to prove his lack of knowledge or to prove that he was aware, but he did his due diligence to prevent the commission of an offense, but he failed. Now, what is the standard of proof required of him to prove that and get acquitted? Ordinarily, when the law shifts the burden of proof to the accused, the standard of proof is within the balance of probability. Director ordinarily is not required to prove his innocence beyond reasonable doubt. It suffices if his story raises reasonable doubt that he was unaware or that he was aware and he did his due diligence to prevent the commission of the offense, but he failed. But surprisingly, we have some laws, regulatory laws, that require the directors, managers, to prove their innocence beyond reasonable doubt. Such laws are Section 55 of the Media Services Act, Section 28 of the Standards Act, Section 31 of the Cash Nuts Industry Act, Section 13 sub 1 of the Foreign Exchange Act, Section 28 of the Private Hospitals Regulations Act, Section 17 of the Private Health Laboratories Regulations Act, and so many other laws. These regulatory laws require the directors to prove the absence of knowledge or the due diligence they did to the satisfaction of the court. The word used in these laws is prove to the satisfaction of the court. What does this phrase, to the satisfaction of the court, mean? This phrase, to the satisfaction of the court, has been interpreted by our courts to mean beyond reasonable doubt. So this means directors, some of the laws require directors to prove their innocence beyond reasonable doubt. But some of the regulatory laws do not require directors to prove their lack of knowledge or due diligence beyond reasonable doubt. So when the law does not say prove to the satisfaction of the court, it means director or a manager will be required to prove his lack of knowledge or the due diligence only within the balance of probability, only to raise reasonable doubt. Another frequently asked question is, what if the directing mind is acquitted? Can that affect the conviction of a corporate body? In other words, if director is not found guilty, does that necessarily mean the company should also be found not guilty? The answer to this is no. Why the answer to this question is no? Let's go back to the imputation doctrine. Company is held criminally liable because someone within the company, an individual, not necessarily director, an individual has committed an offense. So the criminal liability of an individual within the company is imputed to the company. And then the liability of the company is imputed to the director. So the director may successfully prove his lack of knowledge, and that is enough to get him acquitted. But a mere fact that the director has proved his lack of knowledge and he has been acquitted does not mean the crime has not been committed. It only means the director was unaware and could not prevent the commission of the offense. But still the company will be held criminally liable because there is proof that someone within the company committed the crime, and the criminal liability of such individual has been or is imputed to the company. What is needed to be proved is there is a crime, and this crime has something to do with the company. It was committed in the course of discharging the company's duties or objectives. That is enough to have the company convicted, even without necessarily identifying which individual in the company committed the offense. Now let's look at how do we arraign corporations or companies. There are two ways. Director and the company. Director can be arrested and get charged along with the company. The second way is a summons may be issued to the director to attend before a law enforcement agent or to appear before the court. That's another way of getting the company before the court of law. And once charges are prepared and presented before a court of law with competent jurisdiction to try the offense, director or any person authorized by the company can appear and plead on behalf of the company. But director, being an individual, will appear himself and will enter a plea. So there are situations where director is pleading on his own behalf because he has been charged as a director, and also pleading on behalf of the company because he is the corporate mind. He is the company. In criminal law, corporate mind is the company. Director is the company because the company thinks through director. The company behaves or misbehaves through directors. So directors can plead on behalf of the company. And what I mean when we are saying directors, we mean those who are in charge of the affairs of daily operations of the company. When director and the company are charged, if the first charge is bailable, director can be admitted to bail, but the company does not need bail. Only director or a manager will need to seek bail if charged with a bailable offense. Now, what are the ways of proving corporate criminal liability? We have said there are two ways, depending on the nature of the offense committed. if the company and directors are charged under penal statutes which do not have a specific clause for corporate offense or corporate liability, then the prosecutor has to prove the actual involvement of the director in committing the offense charged. But if the director and the company are charged under a regulatory law, prosecutor is required only to prove that the crime was committed within a workplace. Then the liability of that unknown criminal is imputed to the company, and then the liability of the company is transferred to the director. So the easiest way for prosecutors to successfully prosecute directors and companies is to charge them under regulatory laws. I'll give you an example of uttering false document. If a company submits false return or false tax claim refund to the tax authority, prosecutor has two options. He can charge the company and the director for the offense called uttering false document, contrary to section 342 of the Penal Code, or he can decide to prosecute the company and the director for a similar offense under section 84 of the Tax Administration Act. Now, if the prosecutor decides to prosecute the company and the director under the Penal Code, the prosecutor will be required to prove the actual involvement of the director in submitting that false document to the Revenue Authority. But if the same conduct is charged under the Tax Administration Act, section 84 of the Tax Administration Act, then all what the prosecutor is required to do is that a false document was submitted to the tax authority. Then the liability or the criminal liability of that unknown person who submitted it to the tax authority shall be imputed to the company, and then the guilt of the company shall be imputed to the director. So the simplest way to have these directors and managers convicted is to charge them under regulatory laws. Well, most of the time, prosecutors would prefer charging directors and managers and companies under penal statutes, because the penal statutes provides stiffer sentences compared to regulatory statutes. What are defenses available to corporations? Corporations can offer a defense that the conduct being charged as a crime against the company was intended even to defraud the company itself. That the individual in the company committed that offense even against the company itself. In other words, the company can say it is also a victim of the offense. So if proved that the company is also a victim of the offense committed by a known individual in the company may not be held criminally liable, can be acquitted. Another defense that the company can raise is the company has put in place all the compliance policies tailored to detect and prevent the offenses most likely to occur in the course of company's operations. So when this is proved that the company has been doing all what is possible to do in order to comply, then that may be enough reasonable doubt to get the company acquitted. Now, what are the defenses that might be available to a director? Director can plead lack of knowledge, that he was unaware of the commission of the crime, or that he did his due diligence to prevent the commission of the offense, but he failed, or that he was not in a position at the time the offense was committed. If, for example, director was appointed to a position he's holding in 2020, but the crime being charged was committed in 2018 or 2019, director can plead that as a defense, that he was not holding the position at the time the offense was committed. A director is held criminally liable by virtue of his position, but that position should be the position he was holding at the time the crime was committed. Now let's look at the sanctions. Penalties. Why corporations are being criminally punished? One of the reasons is deterrence. When directors are held criminally liable, and when companies also are held criminally liable, that deters commission of crimes within the workplace. The second reason is confiscation. It is easy to recover proceeds of a crime from the company when both the company and the director are charged. For example, if the company was overpaid in a public procurement, or there is a tax avoidance, tax evasion, if there is tax evasion committed by the company, it is easy to recover the tax evaded or the payment overmade to the company if the company and the director are both charged. Because directors are the paymasters. When they are charged and the company is found guilty, and they are also found guilty together with the company, it is easy for the prosecutor to recover the proceeds of crime from the company. The third reason is to simplify investigation and prosecution. In large corporations, it is difficult most of the time to investigate and be able to detect or determine the actual perpetrator of a crime. So the simplest way now is to charge the company, because when the company is charged, there is no need of identifying who was the actual perpetrator of the offense. All what the prosecutor is required to do is the crime was committed within a workplace. That is enough to hold the company criminally liable. And that is enough to compel the companies to pay compensation, fine, or anything required by the law to be imposed to the director or the company as a punishment. Another reason is to force directors and companies to set compliance policies. When directors are criminally charged, they are compelled to put in place the compliance policies, because no director would wish to be prosecuted every time. So the only way for the director to be safe, if he sees there is a danger of being prosecuted, is to put in place the compliance policies and to even impose administrative sanctions for staffs who do not comply with those compliance policies. There are so many reasons, but now let's look at the penalties that are normally imposed. One of the penalty, the common penalty or sentence which is commonly imposed, is fine. And even where the offense charged do not have fine as an alternative sentence, still Section 71, subsection 3 of the Interpretation of Laws Act provides for a formula for conversion of the prison term into a fine. But a question that is normally asked on this is, if both director and the company are found liable, is it possible to impose a fine sentence on the company and imprisonment sentence on the director? The answer depends on the nature of the charge. If the company and the director are charged under regulatory law, mind you, under regulatory laws, the guilt of the director, the guilt of the company is imputed to the director. This means the director becomes guilty because of the company, not because of his individual conduct. It's because of the company. So if the company is held criminally liable and the court decides, and of course the court has only option of imposing alternative sentence against a company, then if the court imposes a fine against the company, that same court cannot impose custodial punishment against the director, because the director is guilty because of the company. The director is not guilty because of his individual conduct. But if the director is charged because there is a proof of his actual involvement in committing the offense, then the court can impose different penalties to the company and the director, because the director is not convicted because the guilt of the company has been imputed to him. He's also held guilty because of his actual conduct. In other words, where there is a proof that the director did actually take part in committing the crime. It is actually the company that becomes guilty because of the director, not the director becoming guilty because of the company. So these are two different ways. Under regulatory laws, the director becomes guilty because of the company. But if there is proof that the director is the actual perpetrator of the offense, it is the company that becomes guilty because of him. So if that is the situation, then the company can be sentenced to pay a fine, and director can be sentenced to serve prison term. Another common penalty is forfeiture. Forfeiture is commonly imposed. For example, where there is overpayment in a public procurement, then the court can order the forfeiture of whatever proceeds the company or the director got from committing the offense. The third common punishment or penalty imposed is restitution order. Restitution order is the court may order the director and the company to restore any property illegally obtained. Another punishment is compensation. If there is loss caused by the conduct of the company or the director, both can be ordered to pay compensation to the victim. Another penalty is probation. The company can be given time or a probation period within which it should comply. This probation penalty is commonly given where the company and the director are charged for regulatory offenses. The company can be blacklisted or disqualified from participating in public procurement, for example. So these are just some of the sanctions that the court can impose against directors and the companies. Now, let's look at what if the director and the company refuse to comply with the court order. The court can issue a distress warrant to attach movable or immovable properties of the company and have them sold. The director or managers can be prosecuted for contempt of court or disobedience of law of order. And the law also allows taking the directors to prison for failure to comply. So the court may afterwards order that director be sent to prison. But when director is sent to prison for failure to pay compensation or the fine given by the court, then the maximum prison term the director will serve is 6 months. So that's it. That's it regarding corporate criminal liability. But the most important thing now to summarize, the most important thing is when taking the position of a director or a manager, before you accept the position of a manager or a director, you have to do your due diligence to know the compliance level of the company. Why you have to know the compliance level of the company as a director or a manager? Because the liability of a director or a manager is not derived from individual conduct of the manager or a director. The liability of a director or a manager is imputed, is derived from the liability of the company. And the liability of the company is derived from the criminal conduct of someone within the company. Director can be charged and the company can be charged with any offense, even the offenses that require proof of mens rea, the guilt intent. So the guilt intent of someone within the company is deemed to be the guilt intent of the company, and is also deemed to be the guilt intent of the director. The criminal conduct of someone within the company is deemed to be the criminal conduct of the director of the company, and such criminal conduct of the company is also deemed to be the criminal conduct of the director. So the director has to make sure, directors and managers must make sure they enhance level of compliance within their companies as the only way to avoid criminal prosecution. Thank you for listening.